HOA property. It is on a property and is owned by the people living behind us. I was having erosion problems. I went to everybody. I went to the guy across behind me and said, hey, can I put up a retaining wall? He gave me permission. Cool. 2004, we didn't ask permission. We just dug on somebody's lot and threw a 6-foot piece of pipe in the ground and did a terrible job of putting it in anyway. No gravel, no rock, no nothing. Rip wrap around the joints. So now we are actually we've dug up that pipe that we put in illegally in 2004 and are now putting new pipe on someone else's property without their permission. And because Melissa has been told that multiple times, I'm not sure what your purpose as a board is if you're going to let people do whatever they want. And to me, if I decide I want to put a vegetable garden up and grow tomatoes, corn, watermelons, and I make it a 10 by 10 thing and put it centered on our property line, well, you could say that's an easement on the side of your property. But if I don't ask you permission, should I be allowed to put my vegetable garden on your lot? But that's what you are letting us guys do to the people who abut behind our neighborhood. And I just find that's wrong on so many levels I can't see straight. And my wife told me not to get mad. But I have talked to Melissa. I believe Melissa has done a terrible, terrible job on this. I have already told her I am going to file a written complaint against her, which I hope will go in her personnel file. And basically, that's why I just wanted to let you know that your people are letting the people in the neighborhood down. And when I kept asking about it, and I asked her to send out an inspector, well, it's pipe for pipe. We don't need to do that. So they had actually brought in about almost 290 foot of pipe when there was 280 in the ground. They're now cutting part of the pipe off because it's too long. So by doing that, instead of the curve, the straight line, they did save us probably 20 foot of pipe. But they also did the things that we were told would not happen by Melissa. That the pipe would not be shifted in place. And when, I don't know how you feel about having something put on your yard without your permission, but I'm a firm believer that the people behind us probably wouldn't be happy. Unfortunately, that lot's it's behind Dairy Queen there in Scott Depot, and it's been on sale for years because the guy died and the kids want too much money. So they're not even around and don't care, but I care about what you do to your neighbors. So that's all I had to say, and if you guys have any questions for me, I'll be more than glad to answer them.
Well, thank you for your comments. As far as this goes, I don't really think that we really have any comment at this point. What I'd want to do is look into the situation before I would make any public comment.
I do have one question.
Yes, sir.
My question would be, from 2004, when the original pipe was put in, was your subdivision, everything that drains to that pipe, upstream of that pipe, was it already there, or would you say that development has occurred post-2004 that drains to that pipe?
No. And actually, I have a copy of the plot map. I should have brought it with me. But the storm drain system actually runs, like I said, behind about 5 lots. There's only 5 lots involved with this per se. But in 1999, when it was developed, it was an open culvert there, which it still is, and there was an open culvert across to the pipe under the road, which had to be there for the road to go in, and then it's open culvert all the way on the other side. And that was all there in 1999 that way. And going, again, it was years ago. So I've been doing a lot of research on this stuff, and I found a note with pictures from the board of the HOA in March of 2004 showing that when Aaron Knight had built that house, it was about, the corner foundation was about that far off the creek. And they said they were sending letters to Andy Haymaker, to Aaron Knight, and everybody else and the grandmother, telling them that house was too close and we would not be responsible for any damage or slippage that occurred to the foundation because of it. Well, suddenly, when they asked to put the pipe in, they now have a deck behind that house, and the thing runs behind the deck. and then comes up. So where before it was like 18, maybe 2 foot away from the foundation, it's now like 12 foot that way and that way. So it was altered in its original location by Rick and Glenn back in 2004, and is now being altered again. And don't take me wrong, I like Tully. He's doing a great job putting the pipe in. I can't complain about the work he's doing. I have complaints about some of the things, like you're supposed to have 3 foot clearance between sewage lines. I can show you a picture where it's laying right across the pipe, and he had no choice. Apparently there were 2 lines, and one is 12 foot down and one was 5 foot down, and he's trying to put a 6 foot pipe in between the 2. There's no way in hell he's gonna get 3 foot of clearance. So I will not fault him on that. And I do think he's done a good job. The problem is, the original estimate that the board got was from Dave Thompson. Dave Thompson doesn't know squat about what he was doing. And I knew before the construction started that he had already subcontracted it to Tully to do the work. So, the work is all pretty much done, and there's not much at this point I think can be done about it. But I want it noted somewhere that there was a problem with this, and you guys failed me.
Well,
That's the bottom line.
I appreciate you coming out and speaking, and I will tell you that we have a personnel committee, and I will see that this gets referred to that. From an engineering standpoint, I have some concerns. I don't want to speak without knowing more about it, but it's something we will, we'll look into it.
I had contacted Jimmy Calhoun. I was going to pay out of pocket to do the engineering studies, and if you don't know, he recently had a stroke.
I did not know that.
Yeah, he
That's
did.
terrible.
And he's not back at work yet, so I did not get my engineering study done before the pipe went in the ground. So at this point, I think it's worthless to do it, because if you find out you're wrong, we'd have to pay to dig it up and put it back in again. But I will say the way they were grading was they were putting a 6 foot level on top of a 25 foot piece of pipe and making sure it was level. And somehow or another, from an engineering point of view, I don't think that's the way to do business. But again, Tully's working, and I like the guy, and I think he's doing a good job compared to the way the barn is being banded and the things like that. But it's just, I'm really upset about this whole deal.
Okay, well, we appreciate your time. We'll look into it and gather more information.
All right, thank you very much, sir.
Thank you very much.
Thank you.
Is there anyone else that would like to speak on an item that's not later to be addressed on the agenda? Okay. With that being said, let's move on, and we'll open up our public hearing at this time. Is there anyone that would like to disclose any conflicts? Okay, hearing none, let's go ahead with our staff presentation.
Oh, yes. Okay. This is variance request 2021-01, Gary Sims. Gary Sims, Valley Point Properties LLC, is requesting a variance from Article 200.02, Design Standards and Table I, Minimum Design Standards for Roads, specifically the pavement requirements for the cul-de-sac pavement located at Tax Map 222E, Parcels 62 and 62.1 in Hurricane, West Virginia. The authority for this lies in Article 1400.03, which provides that the Planning Commission does hereby exercise the power and authority to review, approve, and disapprove plats for subdivision land within the boundaries of the county which show lots, blocks, or sites with or without new streets or highways. Article 1400 and Section 1400.13 is waivers or variances. When the Planning Commission finds that extraordinary hardships or practical difficulties may result from strict compliance with these regulations and/or the purposes of these regulations may be served to a greater extent by an alternate proposal, it may approve variances to these subdivision regulations so that substantial justice may be done and the public interest secured, provided that such variances shall not have the effect of nullifying the intent and purposes of these regulations and further provided, the Planning Commission shall not approve variances unless it shall make written findings based upon the evidence presented to it of the following conditions, and that the conditions are being met. Number one, the granting of the variance will not be detrimental to the public safety, health, or welfare, or injurious to other property. Number two, the conditions upon which the request for a waiver of variance is based arises from spatial conditions or attributes which pertain to the property for which the waiver or variance is sought and which were not created by the person seeking the waiver or variance. Number three, the waiver or variance would eliminate an unnecessary hardship as distinguished from a mere inconvenience and would allow the intent of the subdivision regulations to be observed and substantial justice done. Number four, the waiver or variance will not in any manner vary the provisions of any other regulations, ordinances, or plans adopted by the county. Number five, in approving the waivers or variances, the Planning Commission may require such conditions as will, in its judgment, secure substantially the objectives and standards or requirements of these regulations. And number six, a petition for any such waiver or variance shall be submitted in writing by the subdivider. The petition shall state fully the grounds for the application and all the facts relied upon by the petitioner. Article 1500.02 is a definition for variance and a waiver. A variance/waiver is a deviation from the minimum standards of the subdivision regulations. Article 200, specifically Section 200.02I, design standards. The general provision is that you see Table I, minimum design standards for proposed roads. The next page of your packet deals with the table I, minimum design standards for roads, states that the pavement requirement for non-residential subdivisions, and the second one down is cul-de-sacs. It says all roads, 60-foot right-of-way radius, 35-foot road pavement status, or radius. The facts of the case. Gary Sims of Valley Point Properties LLC is requesting a variance from Article 200.02 Design Standards and Table I, Minimum Design Standards for Roads, specifically the paving requirements for the cul-de-sac pavement located at Tax Map 222E, Parcel 62 and 62.1 in Hurricane, West Virginia. The applicant has submitted a Planning Commission appeal application requesting a variance to not be required to pave the cul-de-sac since it would be torn out when Tract 5 is developed. A copy of the submitted application and disclosure statement are included as Attachment A. The applicant has submitted an explanation and a response to the conditions found in Article 1400.13 of the Putnam County Subdivision Regulations. A copy of the submitted explanation and responses are included as Attachment B. AB Contracting, Inc., the prospective developer for Tract 5, has submitted a response to Mr. Gary R. Sims Sr. regarding the removal of the cul-de-sac at the start of the construction. A copy of the intent letter is attached as Attachment C. The property is zoned as C1, Suburban Commercial District. A copy of the zoning map is included as Attachment D with the tax parcel outlined in blue. The approved preliminary and as-built plats are attached as Attachment E. The preliminary plat was approved on March 16, 2018 for 4 tracts out of the 5, with the cul-de-sac to be constructed in asphalt. A copy of the plat with the cul-de-sac highlighted in orange is attached as Attachment F. The as-built final plat was approved on October the 26, 2018, which depicts the existing cul-de-sac is gravel and is highlighted in orange as shown on Attachment G. Photographs of the existing road and the cul-de-sac are attached as Attachment H. The variance request and public hearing details were legally advertised in Hurricane Breeze on September 30th, 2021 as required. On September the 21st, all abutting landowners within 100 feet were legally notified of the variance request in the public hearing. On October the 13th, 2021, a site Signed, notice of the public hearing and variance request was posted at the site as required. And to date, we have not received any written or verbal communications or comments or questions about the variance that is being requested in this. There is a worksheet attached. It is, if you will go to the very back and count in, it's the 7th page from the back. It's right after the photographs. And that is the worksheet that has to be completed for this.
I have one question for you, Larry. I just want you to confirm that. And facts number 8, it says the final as-built plat was approved on October 26th depicting the cul-de-sac as gravel. That means that that was the final map and the planning commission approved that final map.
That's correct.
Then I got a question. Why are we here? Mr. Sims is not asking to change an approved plat. So I question, one, the need why this office is making him get a variance for a map that shows existing conditions as being gravel, and Mr. Sims is planning to keep that gravel. We've approved this as gravel, and I don't see a need for this to be a variance. It seems that Mr. Sims should be able to sell the property based on the approved map and approved condition that this board and planning department has granted based on attachment G.
Well, the problem is that the original plat that was approved showed that it was going to be asphalt. The as-built plan shows that it is gravel. So there is a variance, there is a discrepancy, let me say it that way, between what the original plans were going to show and what the as-built was.
I guess my follow-up question is, in that situation, what supersedes?
Excuse me?
Is there one that supersedes the other? That's my question. I guess my question is, why did we approve an as-built if it was supposed to be paved?
Well, that is the submitted as-built. And I don't know that that has ever come before the Planning Commission. That was just something that was submitted to our office. But that's the as-built, and it is not completely consistent with what the proposal was for that gravel. And that's an issue that, since there is a discrepancy between the two of them, it is not something, it requires a variation that the planning office cannot do in-house.
I think that's
That's something.
Follow-up, originally, it was supposed to be the road there that is asphalt, and then an asphalt cul-de-sac.
That's correct.
Right. That was never done. We got a gravel cul-de-sac,
approved the final plan
and that was approved.
on October 26th.
Well, is someone telling him he needs to pave it now?
Yes.
Who?
Our office.
Apparently our office.
Well,
Now, correct me if I'm wrong, if Mr. Sims was not,
Can you speak into the
if
microphone?
Mr. Sims was not selling this property and was going to extend the road as future development to Track 5, we wouldn't make him pave a gravel cul-de-sac for him to rip it out and then extend that road, correct? He would just be
That's-
allowed to extend the road.
yeah,
That's my
This is-
understanding.
that'd be silly.
Wouldn't the precedent be the most recent document that's been approved legally? Would the precedent be the most recent document that received approval?
With the what?
Would the precedent be the most recent document that received approval? Since the as-built was more recent than the original plat map, wouldn't the as-built be the document that would be approved?
I mean, if it was approved,
Because I think what Mr. Asbury's pointing out, what he's trying to do, make sure if you run into a circumstance like this in the future, there's a precedent in order to not basically
Right.
make a developer have to go through
I
something
mean,
like this.
it should not have been approved, but it was. So, I mean, what's on the ground out there now is approved. So, as far as I can tell, he can go ahead and sell the property, doesn't have to pave the cul-de-sac. Then when he wants to develop, extend the road on out, if that needs to be approved, then he can come back and ask for that to be approved.
And I would say that he should not be required to have to get a variance in order to
No.
sell that property when we've already approved.
He's
The
asking
existing
for a
condition.
variance to give him exactly what's on the ground out there now that's already been approved, right?
Well, but it is not consistent with the original plat that was approved by the Planning Commission.
My argument, at least from the professional side of this, would be that once that as-built plat was approved as existing conditions, that supersedes any previous design documents. That's the way as-builts work. It's a record of what was constructed. If it was an issue that it was not constructed per plan, it should have been addressed prior to the as-built being approved, and it should have been remediated then. That wasn't done. That's an error out of this office, and it is not the applicant's fault, nor should he be required to go back and fix that or ask for a variance to correct something that should have been approved or should have been mediated prior to an approval of an as-built.
I totally agree with all that. But apparently, I mean, he's filed this now, so maybe belt and suspenders? Because I don't see any of these questions being answered no.
Well,
So,
I guess my question is if it's the will of this board, can we make a motion that a variance is not required and we approve, that we stand by the as-built that's already approved?
but the as-built has not been approved.
okay, that changes it.
Yeah.
And number 8 was incorrect, is that what you're telling me? Facts number 8 said that, that's what I started out this conversation with.
Right. That's my concern.
Number 8 says the as-built final plat was approved on October 26, 2018. Is that a correct or incorrect statement?
Yes, well, I guess it was. I take that back then. I was thinking it had not been approved, but yes, it has been approved. I take that back.
I would take it a step further. My question then is also, has Mr. Sims had to pay a application fee in order to submit this application?
Yes, there's a $200 application fee.
My position should be that the county refunds Mr. Sims' $200 application fee, pull the variance, and he can go sell this property, because this is not needed.
If you like a motion to that effect, I'd make that motion.
I'll be glad to make it or second.
I move that, in light of the fact that the as-built plan was approved, in my view, that superseded the original plan. And therefore, what's on the ground out there now is approved. And he doesn't need a variance, so for that reason, I move to,
Hang on. Do we have to close the public hearing before you make that?
Yeah, we probably do. And in fact, we probably should stick to the public hearing agenda and the fact that is the developer here? Anyone?
No, my name's Eric Embry. I represent the developer. I'm an attorney in the valley.
Do you have anything you'd like to add or?
No, I think you guys have done a great job.
Does anyone have any questions for Mr. Embry? Okay. Well, hearing none, then we will close the public hearing portion. And we'll entertain your motion.
I'll continue that with what I was saying earlier, make that motion that we refund Mr. Sims his application fee and let him proceed on.
So we have a motion, we have a second?
I second Mr. Dodger's motion.
Okay. All in favor, say aye.
Aye.
Opposed? Thank you, Brian. Opposed, same sign. Okay, motion so moved.
Did this come up before?
At the end of the last business meeting,
All right.
I asked about it.
I'd ask Jacob to pose this question.
All right, let's move on to the next item on the agenda. Before we get into the staff report, Larry, you have somebody to introduce to us?
We do have, it's been kind of a long process, but we do have a new planning director. He is with us this evening. His name is David Call.
David, tell us a little bit about yourself. Come to the microphone.
Well, I've been in the architectural field since 1992, and I've been working for myself for the last 10 years, and COVID has sort of put a big wrinkle in that, so when this opportunity came open, I jumped on it, and I'm glad to be here. It's my first meeting, good learning experience.
And you started at the beginning of October.
Yes, October 1st.
You getting a feel for it so far?
I'm getting my feet wet, yeah, absolutely.
Well, good luck diving in. We want to welcome you.
Thank you very much, appreciate that.
Thank you, thank you.
Welcome, and I think we'd be remiss not to, one, thank Larry for your service to us and the great job you've done and the added additional workload that you've undertaken. It has not went unnoticed, I don't think, by this board,
Not in
and we
the
greatly
slightest.
appreciate you.
Here, here. Okay, do we have a staff report?
I do, just briefly, attached here in the back of your packet are the permit approvals that have, and monthly reports. And the one, that's the last 2 pages, gives you the status of the applications that have come in and where they are at this point. You will see that the vast majority of those, there are only just a few of them that are holding for additional information or waiting for information. The rest of them that have come in, basically, it covers a period, the latter part of April through September, and there may even, on the second page, maybe even some of them from October that we have completed. Yes, there are. So there are a number of them. As you can see, the vast majority of those that have come in have either have been dealt with. Permits have been issued and mailed and emailed out to the applicants. There are a few of them there that are still waiting for additional information, but we just have to get that information before we can proceed on. So the vast majority of those have been taken care of in a very timely manner, other than just waiting for additional information from somebody on the outside.
I got a question you might not be able to answer yet, but the pending court case on Valley Outdoors, how does that change, or what would change based on the new ordinance revisions that were approved at the county commission?
Well, and there are a number of ways it can go. Since the ordinance has been changed, I would think that Judge Stowers could go ahead and make his ruling based on what the ordinance was at the time. He could indicate to the attorneys that now it's been changed, and as a result of that, it's basically taking care of itself. So, I mean, I think he's got a couple of things available to him, but at this point, to my knowledge, nothing has been ruled on by Judge Stowers.
How long's it been pending?
Excuse me?
How long's it been pending there?
Oh, it's been a couple of months, or a month and a half, probably.
So it's not that old.
No, it's not that old.
Any unfinished business?
No, not to my knowledge.
Any new business?
No, other than, like I say, we got a new director. And I think I'd mentioned this at one of the planning meetings. Even before he came on board, he was asking us for copies of the zoning ordinance, the US 35 quarter G management plan, the Tays Valley plan. He was reviewing that stuff before he ever stepped through the door.
To follow up on an earlier comment, I'm probably going to be in contact with David Mills this week, and I'm going to ask him to do some investigating about the comments earlier in the meeting. So just, I know that we've got a new director, and I definitely want to keep him involved, but also you've been here, so if you could help him with that investigation, Larry, I greatly appreciate that.
Okay.
Anybody have anything else to add? Okay, if not, meeting will be, oh, whoa, one more thing. We do have an upcoming special meeting, the 26th, next Tuesday. And once again, if you can make it in person, we would appreciate it. If not, if you could phone in like we've seen 3 members do today, we'd appreciate that too. Just 2 items on that agenda as well, so it should not be a long meeting, I hope. And we would greatly appreciate it.
If anybody can possibly respond to my emails or a call or anything, it really helps.
Save you a little bit of work, wouldn't
Really
it?
appreciate it.
Okay. When do you anticipate sending out the meeting packet?
It will be the next day or so, by Thursday.
By Thursday, so keep an eye on your emails. All right. This meeting shall be adjourned. Hey, thank you, my friend.